Repeal, second reading.
Honourable Attorney General.
Mr. Deputy Speaker, sir, I move that the Legal Aid and Legal Assistance Bill 2025, number 13 of 2025, be read a second time. Mr. Deputy Speaker, sir, amongst the reforms I have introduced in this House so far, this bill holds for me a special place. As a law practitioner of 4 decades now, I have seen the workings of our judicial system up close, and especially the effects it can have on the lives of our citizens. The confusion and loneliness which one can feel when confronted by rules and procedures one does not understand, the helplessness of knowing that one may have a legal right, but that to defend it would be beyond one's means, is more often than not unbearable. Justice in this country has over the decades earned its reputation of quality and integrity, but it also carries with it, increasingly unfortunately, the perception that it is a system that only works well for you if you can wait for it and if you can pay for it. This cannot go on. This morning itself, Mr. Deputy Speaker, sir, in the L'Express newspaper, we have read about the plight of single parents who struggle to overcome financial, legal, and administrative obstacles. As the article rightly puts it, and I quote, "La seule solution reste le tribunal avec des délais longs, des coûts élevés et un épuisement émotionnel garanti." My colleague, the Minister of Gender Equality and Family Welfare, is tackling this particular issue as explained in the article. Thus, Mr. Deputy Speaker, sir, the challenge of making access to justice easier and more affordable remains as crucial as ever. The bill before the House today tackles a question that is fundamental: whether our justice system still serves the many or increasingly only the few. It invites us to consider what it truly means to say that we are all equal before the law. The legislation which we propose to replace dates back to 1973. That was a different time, a different society. In the 50 years since, our courts have modernized, our population has grown, our economy has evolved, but the legal aid framework has barely moved. What we bring before the House today, Mr. Deputy Speaker, sir, is not a mere amendment, but a comprehensive reform. It seeks to restore legal aid to its rightful place as a living, relevant instrument of fairness and the rule of law. Mr. Deputy Speaker, sir, the purpose of the bill is simple and vital. It is to ensure that those who cannot afford legal representation are not left without recourse, whether before the courts or at the police station, whether in civil disputes or criminal proceedings. The state should step in to ensure that legal representation is available for people who are in financial need. To that end, this bill, firstly, raises the eligibility thresholds of legal aid for both income and assets, reflecting present-day economic realities. Secondly, broadens the scope of offences for which legal aid and assistance may be granted. Thirdly, imposes obligations on both the courts and police officers to inform individuals of their rights to apply for legal aid and legal assistance respectively. And fourthly, simplifies the process through a unified application of the system. It also provides, for the first time, a comprehensive definition of assets and strengthens the guarantees of fair legal representation at both trial and pre-trial stages. Mr. Deputy Speaker, sir, let us begin with the basic figures. Under the current law, an adult earning more than $15,000 a month is generally excluded from legal aid. For legal assistance during a police inquiry, the limit is even lower. It's 10,000 rupees. These figures have not been revised since 2018. Yet in the same period, the minimum wage has gone from 9,000 to 17,000 rupees. And the prices of basic commodities have soared by 30 to 100%, as detailed in the Prime Minister's report on the state of the economy earlier during our mandate. The result is obvious. Someone earning minimum wage today is too poor to pay a lawyer, but considered too rich to qualify for legal aid. That is not a small flaw. It is a breakdown of the system's whole purpose. This bill sets a new income threshold, 25,000 rupees of average monthly household income, but calculated on a net basis. I will explain this. Yes, we're including in the calculation the income of one's spouse if one is married, but crucially, this sum will be the net income that someone can actually use and spend. That is, what is left after deducting from his earnings his average household expenses and the repayment of his debts. For instance, a couple may be earning salaries of 30,000 each, gender equality, amounting to a total of 60,000 for both of them, but they may have expenses such as a housing loan of, say, 20,000 rupees, utility bills of about 5,000 rupees, regular grocery bills of 15,000 a month, spend 5,000 on their children's school van. In total, their average monthly income for the purposes of this law would not be 60,000, but 60 minus the 45 which I've just detailed, that is 15,000. They would therefore fall under the threshold of this bill and qualify for legal aid. Mr. Deputy Speaker, sir, as everyone will understand, this reform will bring about a substantial expansion in the number of people eligible for aid. It is nothing less than a reinforcement of the welfare state. In this government's opinion, it is obviously an acceptable price to pay for justice to be fair. Of course, this exercise of scrutinizing the finances will be monitored by the courts to prevent any false or exaggerated declaration of expenses. But we will prefer here to err on the side of generosity, which is why there is no list of what type of expenses are allowed. The reason, Mr. Deputy Speaker, sir, is that experience has taught my colleagues and me at the bar that almost no one who can easily afford to pay for their own lawyer will instead choose a court-appointed one instead, not when their legal rights or their freedom is at stake. This is why we are confident that this new law will not open the floodgates to unmeritorious application. Mr. Deputy Speaker, sir, the spouse's income will, however, not be counted in divorce or separation matters, which is only just and reasonable. The maximum value of assets to be eligible would also increase from 500,000 rupees to 1 million rupees, excluding, as the law will have it, clothing, work tools, and the subject matter of the case. This again reflects the rising cost of living. This bill also provides for a broader definition of assets to include not just cash and bank deposits, but also investments with non-bank institutions, shares, bonds, stakes in companies, etc., whether in Mauritius or abroad. Despite these stated thresholds, the court is given a margin of discretion in cases where a person of low income may still own assets worth more than 1 million rupees. Because there can be times when, for instance, it would be unfair to ask someone of low means to sell an inherited plot of land just to defend a case against him, especially if that land is still en division. Mr. Deputy Speaker, sir, these are practical, sensible reforms, but they are also moral choices. We bring them not because they are popular. They do not provoke public interest, debate, or outcry. The example is here for all to see. The opposition have not even deemed it fit to intervene on this very important piece of legislation. Mr. Deputy Speaker, sir, these are there is no electoral dividend in expanding legal aid, which is probably why the previous government, so keen on printing money to increase allowances it could not afford, did nothing to change the legal aid thresholds. No, we on this side of this House do not do this because it is popular, but because it is the right thing to do. The bill further widens the scope of offences for which legal aid may be obtained. Currently, the offences for which a person may obtain legal aid are restricted, and some offences still listed in the current law no longer even exist. A person will now obtain legal aid for any offence before any court, save and except for those district court offences that are not punishable by penal servitude. In other words, only the most minor criminal offences are excluded from the scheme. Mr. Deputy Speaker, sir, access to justice begins not in court, but at the police station. That is where this bill goes further than any of its predecessors. Legal assistance, as opposed to legal aid, which is the right to be advised and represented during police inquiry or bail hearings, has until now been available only for a narrow list of serious offences. The new bill removes that restriction. Legal assistance will now be available for any offence that may lead to an arrest. Moreover, police officers will be under legal duty to inform any person under arrest in a language they understand of their right to legal assistance, particularly before any statement is taken under warning. This aligns our legal framework with the best traditions of due process and protects both the rights of the accused and the integrity of our criminal justice system. These changes will also benefit the legal profession and the administration of justice more broadly. By widening the base of legal aid recipients, the bill ensures a more diverse flow of cases for court-appointed counsel. This is particularly valuable for the younger members of the bar. As many honourable members will know, there is a growing number of junior barristers who struggle to gain meaningful court experience. Legal aid cases, be they in family, civil, or criminal matters, offer real exposure and real responsibility. Barristers and attorneys assigned under the scheme are required to accept such briefs unless disqualified by conflict of interest or manifest lack of competence and expertise. They may not claim or receive any sum from the recipient of legal aid, but they are paid a modest fee by the court. For instance, an attorney and a barrister receive 10,000 rupees each for a case entered by a plaintiff summons before the Supreme Court, 8,000 for intermediate court and industrial court cases, and 5,000 rupees for a district court matter. A barrister appointed for a bail hearing or assistant at the police station is paid 5,000 rupees and only 15,000 rupees for representing a client at the assizes. The relationship is governed by professional duty, not market transaction. This is why the practice of law is not a business, and that is why we are not traders, and this bill ensures that it remains so. Mr. Deputy Speaker, sir, allow me to walk the honourable members today briefly through the structure of the bill. Part 1, the preliminaries, clauses 1, 2, 3, that part sets out the short title, definition, scope of application. It clarifies, for example, that the Act does not apply to disciplinary proceedings and limits its application in certain minor criminal cases. The second part, legal aid in civil and criminal proceedings, clauses 4 to 9, that part establishes the right to legal aid and sets out the eligibility criteria: monthly household income below 25,000 rupees, assets below 1 million rupees. It outlines the application procedure, permits legal aid in criminal appeals, grants special protection to juveniles, ensuring the juveniles are automatically eligible regardless of their needs. Part 3, legal assistance during police inquiry and bail application. These are clauses 10 to 14. This section enshrines the right to legal assistance upon arrest and for bail applications. It sets out the application process before the district court, guarantees the protection for juveniles, including where no parent or guardian is available to act on their behalf. Part 4, assignment of counsel and fees, clauses 15 and 16. Here the court is empowered to assign a barrister or attorney. Lawyers must not request or receive any remuneration from clients under legal aid. The costs awarded in such cases accrue to the state, and any abuse of the scheme may lead to penalties. The Part 5, the miscellaneous provisions, this final part, Mr. Deputy Speaker, sir, provides for exemptions from court-related fees, empowers the Chief Justice to make rules for the purposes of this Act, and for my office to amend the schedule by regulations includes, of course, transitional arrangements. The Act will come into force by proclamation with the possibility of a staggered implementation. The schedule sets out a standardized form of affidavit to be used for applications under both legal aid and legal assistance, streamlining the process and improving transparency. This bill, Mr. Deputy Speaker, sir, will therefore improve the lives of many who find themselves at their most vulnerable before a magistrate or a police officer, or in the quiet loneliness